much for the introduction, Juhi. So thank you for having me. And I'm going to share my screen. Let me, okay, perfect. Okay, I think you can see it. So hi everyone. My name is Simona Mola with Cornerstone Research, and as Juhi mentioned, prior to joining Cornerstone, I was assistant director at the SEC during a time when the SEC started to devote attention to the crypto world. And it's my pleasure today to talk about the SEC enforcement activity in this space. And in the next 30 minutes or so, I would like to touch on three main points. First, I would like to present some statistics about the SEC enforcement activity over time, with particular focus on the last months of COVID-19 pandemic. I will show the number of enforcement actions that the SEC has brought over time, the main allegations, the main defendants that have been charged by the SEC, the main milestone or lesson learned in this space. Second, I would like to focus on those enforcement cases related to initial coin offerings or ICOs that the SEC has brought for failing to register the coins or tokens issued during the offerings as securities. I would like to briefly discuss what it means to issue a compliant ICO. In other words, to issue coins or tokens in compliance with the security laws in the United States. Third, while a lot of attention is devoted to the SEC approach towards ICOs, at the end of my presentation, I would like to touch on other issues that may keep the SEC staff up at night, such as broker-dealer customer custody issues, Bitcoin, ETFs, and stable coins. Okay, let's get started then. Any discussion about the SEC enforcement activity in the crypto space starts by mentioning the Dow report of investigation issued in July 2017, followed by the cease and desist order issued again against the Munchie in December 2017. So while the Dow report and Munchie are important milestones, as we are going to discuss later, the SEC started to be active in crypto in 2013 with the first enforcement action against shavers. In particular, in July 2013, the SEC charged Trendon Shavers and his company, Bitcoin Savings and Trust, with defrauding investors in a Ponzi scheme involving Bitcoin. Just to translate the SEC enforcement activity in numbers, since 2013, the SEC has brought 31 litigations, 25 administrative proceedings, and 15 trading suspensions. So let's clarify these terms, given that we are going to use them often in the next slides. So I'm sure that you are familiar with what a litigation is. It's a civil action in front of a judge who issues a final judgment to resolve a dispute. And in this case, a dispute between the SEC and a defendant. An administrative proceeding is a non-judicial process. It typically starts with a confidential investigation where the SEC approaches a respondent with an alleged claim and requests a great deal of information. At the end of this investigation, the SEC can decide to let it go or to charge the respondent. If it decides to charge, the SEC issues an order, typically a cease or desist order that requires the charge party to refrain from the unlawful behavior and imposes disgorgement. That is, imposes the return of the unfair profit obtained through the unlawful behavior, plus civil penalties. In trading suspensions, as the term suggests, the SEC suspends stock trading when there are questions about the accuracy of the information distributed to the public, and when there is suspicion of possible market manipulation. In these 15 trading suspensions, the alleged inaccurate information was related to crypto or other blockchain uses. To add to these numbers, the SEC Enforcement Division has also issued subpoenas and follow-on administrative orders. In addition to enforcement actions, there's been a number of investor alerts from the SEC Office of Investor Education and Advocacy and several statements from SEC staff and officials. Some of these statements are joint statements with other regulators, such as CFTC, FinCEN, FINRA, highlighting the coordination among regulators in this space. This slide displays the SEC enforcement activity over the last 7 years or so, quarter by quarter. So litigations are reported in gold, administrative proceedings are in silver, while trading suspension orders are in green. As mentioned earlier, the SEC has been active in the space since 2014 with some important litigation. First, SEC versus Shavers in Q3 2013, but also SEC versus Garza in Q4 2015, and SEC versus Edo in Q2 2017. All these 3 cases that I mentioned, in all 3 cases, the SEC alleged a Ponzi scheme. So as the figure clearly shows, well, the SEC enforcement activity has started earlier in 2013. It has become more robust since mid-2017. It has tightened at the time when cryptocurrencies in general and ICOs in particular became popular. So now the pandemic has not particularly slowed down the SEC enforcement activity in the crypto space. So if we look at Q1 2020, there have been 7 enforcement actions, 5 litigation, 2 administrative proceedings. And in the last month, SEC staff has released several statements making clear that it is business as usual. Although the stay-at-home orders may have delayed some court calendars and created some technical challenges, for example, trying to arrange witness testimonies remotely, or seeking emergency reliefs when the courthouses are shut, the stay-at-home orders have not changed significantly the SEC oversight in terms of initiating enforcement actions. This may be due to 2 main factors. First, the SEC staff is well used to telework. It has been used to it for years. Second, previous crises such as 9/11, Hurricane Katrina, the financial crisis, have shown that economic downturns typically raise the risk of frauds to investors, regardless of whether the areas of potential misconduct are strictly related to the causes of the crisis. So SEC officials stated that the Enforcement Division has not devoted all its resources to COVID-related risk. While COVID-related matters are a top priority at this time for the Enforcement Division, other priorities have remained in place, including enforcement in the crypto space. In this slide, I also included investor alerts and some of the most important statements made by SEC staff and SEC officials to highlight how such alerts and statements often played the role of accenting enforcement actions. For example, the first investor alert on a Ponzi scheme using virtual currencies was issued at the same time of SEC versus Shavers. In some cases, investor alerts were issued prior to taking enforcement actions. For example, in November 2017, the SEC warned investors not to make investment decisions solely based on celebrity endorsements. This alert came prior to the SEC charging a couple of celebrities for failure to disclose compensation they receive to promote ICOs. More recently, in January 2020, the SEC issued an investor alert on initial exchange offerings, IEOs. IEOs are similar to ICOs, but they are offered directly by online trading platforms on behalf of a company, usually for a fee. In this investor alert, the SEC has warned investors about the risk that these online trading platforms may not be registered with the SEC, may improperly refer to themselves as exchanges, and may also claim to perform due diligence or other quality assessments of the IEOs. The SEC has already taken action against some registered broker-dealers and some registered exchanges offering ICOs. And we'll see if there may be further actions in this particular area. Finally, I wanted to highlight here, and I highlighted here in green, some of the most important statements, like the speech of a Corpfin director, Bill Hinman, in June 2018. This speech anticipated publication of the framework for investor contract analysis in April 2019, which I will talk about later. So this chart displays the types of allegations in all 25 administrative orders and 31 litigation complaints filed by the SEC. Let's take a moment to clarify numbers and colors in this chart. In the y-axis, you have the number of allegations, while on top of the bars, you have the number of enforcement cases in a given quarter. Clearly, an enforcement action can be associated with more than one allegation. I also realized that there are many colors in this chart. And so in order to navigate the colors, I suggest focusing on the colors at the bottom of the legend. For example, in Q3 2013, there was one enforcement action that I mentioned earlier, SEC versus Shavers. That enforcement action had two allegations, one fraud allegation in green and one allegation of unregistered security offering in gold. The main takeaway of this chart is that frauds and unregistered security offerings are the most frequent allegations. So just to provide some statistics, overall, 50% of the 56 litigation administrative proceedings contain an allegation of fraud under Section 17A of the Exchange Act and or Section 10B or Rule 10b-5 of the Exchange Act. 70% of all litigation and administrative proceedings that the SEC has brought so far allege a violation as unregistered security offering under Section 5A and 5C of the Securities Act. In 38% of cases, the allegation of a registered security offering comes in combination with a fraud allegation. Among other allegations, I would like to bring your attention to allegation for failure to register as a broker-dealer or as an exchange. So failures have been alleged in 9 enforcement actions. There have been also allegations of unregistered offerings of swaps to non-eligible contract participants. In particular, 2 actions that I mentioned here were brought by the SEC at the same time of the CFTC. And this emphasizes the SEC and CFTC commitment for coordinating enforcement efforts. Finally, 3, you will see that there are less frequent allegations, such as promotion of securities without disclosing compensation, violation of restrictive periods, reporting violation under Section 13A of the Exchange Act, and so on. In these slides, I wanted to focus on the 31 litigation brought by the SEC. And I would like to highlight 2 main takeaways here. First, almost half of the litigation, precisely 14, are with the Southern District of New York. And almost half have been already resolved, leaving 17 litigations still open as of March 31st. It is worth mentioning that the courts of the litigation already resolved have generally sided with the SEC so far. Second, frauds and unregistered security offerings remain the most frequent allegations. In 61% of the litigation that the SEC has brought so far, the claim of a registered security offering comes in combination with the fraud allegation. Let's focus now on ICOs. Of all SEC enforcement action alleging violation of Section 5A and 5C of the Securities Act, so alleging an unregistered security offering, the ICO-related cases represent a significant portion, nearly 70%. Here are listed the main cornerstones to understand the SEC positions towards ICOs, starting from the Dow report in July 2017, where the SEC clearly identified the Howey test from the Supreme Court decision of 1946 as the test that will be used to determine whether a token is an investment contract. And to constitute an investment contract under the Howey test, all 3 prongs of the test must be met. First, an investment of money. Second, in a common enterprise. Third, with a reasonable expectation of profits derived from the efforts of others. Here I reported the SEC legal analysis in the Dow report. And this same legal analysis was repeated in December 2017 administrative order against the Manchi, which was the first enforcement action that the SEC took to stop an ICO from failure to register its securities. Manchi is also the first enforcement action in the crypto space where the issuer earn credits for cooperating with the SEC. In April 2000, an important milestone to understand the SEC position towards ICOs was the June 2018 speech by CorpFin Director Hinman. In his speech, Hinman stated that neither Bitcoin nor Ether are securities, based on the decentralization of their networks. The speech also contained a first attempt to separating tokens that are securities from tokens that have mere consumption utility. In April 2019, this first attempt was formalized in the framework for the investment contract analysis. The framework takes the position that the first two prongs of the Howey test will be basically satisfied in a typical offering of digital assets, while the third prong, the efforts of others, usually serves as the decisive point. On the same day, the SEC FinHub published the framework. CorpFin issued a no-action letter about turnkey JET token. This no-action letter clarifies that the SEC considers as what the SEC considers as utility tokens. Specifically, tokens that are immediately usable at the time they are sold, tokens whose value is relatively fixed, and tokens whose issuer, promoter, or sponsor does not issue any funds from the token sale to develop any platform, any network, any app, because all platform, network, and apps are already fully developed and operational at the time of the tokens are sold. So the SEC has also taken a similar position in a more recent no-action letter to Pocketful of Quarters, but as you can see, the list of no-action letters and the list of tokens that the SEC consider utilities and not deemed securities pretty slim at this time. Moving to the second part of my talk, if tokens are securities under the Howey test, issuers of ICOs must register the tokens with the SEC under security laws, unless they rely on exemption from registration. Among the available exemptions from registration, 3 exemptions look suited for ICOs, because they all allow general solicitation. So they allow sales over the internet. Regulation crowdfunding, Regulation A, and Rule 506C of Regulation D. So while I was at the SEC, I worked on the adoption of these exact exemptions and other related policies mandated by the Jobs Act of 2012. So from an economic standpoint, these exemptions combine features that balance capital formation and investor protection. In general, the greater is the maximum offering size allowed under the exemptions, the lower the ability to reach out to non-accredited investors and to freely resell tokens in secondary markets. In case you are wondering who are the non-accredited investors, the definition is based on income and net worth. A non-accredited investor is an individual whose income does not exceed $200,000 or $300,000 jointly, or whose net worth does not exceed $1 million. So now going through the available exemption, regulation crowdfunding provides a simple and streamlined option for an issuer looking to raise only small amounts of capital. Given that the median average size of an ICO is approximately $25 million, there may be actually two options left on the table, either Reg A or Rule 506C or Reg D. As you know, Reg A has two tiers. Tier 1 of Reg A does not require audited financial statements or periodic reporting requirements, while Tier 2 does. Plus, Tier 2 offerings are subject to the SEC qualification. But Tier 2 offerings preempt state registration requirements, meaning that the issuer does not need to file in each state in which the offering is made, while Tier 1 does require compliance with state security laws. So both tiers allow issuers to reach out to non-accredited investors, and the token can be sold without any restrictions on resale. Rule 506C of Reg D allows issuers to raise an unlimited amount of capital, but only from accredited investors who would receive tokens whose resale would be restricted. There is some evidence suggesting that more ICO issuers are contemplating Reg A and Rule 506C of Reg D exemption as a mechanism for raising capital in compliance with security laws. However, there is debate about two open questions. First, given that the existing framework was established without any of the unique crypto features in mind, the question of whether such frameworks are suitable for ICOs remains open. For example, given that blockchain transactions are mostly anonymous, it can be technically challenging to verify the accredited investor status or to determine compliance with investment limits for non-accredited investors. Second, the question of whether tokens issued as a security ever stop being securities also remains open. The existing regulatory frameworks don't offer any guidance on the transition from security to utility token. This open question highlights the dilemma that crypto entrepreneurs currently face. Existing SEC guidance requires that distributed ledgers networks must be decentralized for a token not to be deemed a security by the SEC. Networks cannot develop decentralized networks unless the tokens are widely distributed and freely transferable among participants. But here is the regulatory catch-22. Network developers cannot distribute their tokens to participants because their tokens are potentially subject to existing security laws. As a solution to this dilemma, Commissioner Peirce has recently proposed a safe harbor that frees network developers from registration requirements for 3 years, during which the development of a functional, decentralized network could be facilitated as long as the network developers meet certain conditions. Finally, I also wanted to mention that the SEC has recently proposed not only amendments to the definition of accredited investors, but also it has recently proposed to increase the maximum offer amount under Tier 2 from $50 to $75 million in regulation crowdfunding offerings from 1.7 million to 5 million. In addition, the SEC has proposed to amend the investment limit in Reg CF offering. Moving to the third and last point before the conclusions. The question here is, what else keeps SEC staff up at night beyond ICOs and how we test? I listed here some important issues that may keep staff, in particular from the division of trading markets and investment manager, busy. Broker-dealer custody of digital assets, digital asset exchanges, digital asset ETFs, and stablecoin. These issues are very much intertwined, as Chair Clayton's statement suggests. While talking about Bitcoin ETFs, Jay Clayton stated that the SEC still has investor protection concerns in terms of market manipulation, but also in terms of custody. This is particularly important for the SEC because this product typically attracts retail investor interest. The issue of digital asset ETFs is also related to stablecoins in general and to Facebook Libra project in particular. During a related congressional hearing, Facebook received multiple questions regarding whether Libra is an ETF and how it should be regulated. Facebook acknowledged that Libra uses operational mechanisms that are similar to ETFs, but stated its view that Libra is still a payment tool and not an investment vehicle. So if deemed an ETF, Libra would need to comply with the SEC regulation governing securities, investor advisors, and investment companies. As Jay Clayton said, here, Libra is here. We should not go around it. But at this time, the SEC has not taken an official position about it. So to conclude, as visualized in the chart that I showed earlier, the SEC enforcement activity in the crypto space started in 2013. But he has strengthened since 2017, and this has coincided with the increasing popularity of crypto. At this time, the trend that we have observed in the past has remained unchanged in the last months of the COVID pandemic. There is no doubt, I think there is no doubt in my mind that the SEC will continue to be active in this space and will continue to be particularly active to the extent that digital asset transactions are associated with allegedly fraudulent behavior, because this is part of the SEC mission. Given its mission, the SEC must balance between investor protection and capital formation. And finding this balance in the crypto space is not straightforward. So on one end, one may argue that there is need for regulation that fosters innovation. The distributed ledger technology has the potential to disrupt several sectors and foster that innovation. One may argue that digital assets have unique features that require new regulation. On the other hand, one may argue that innovation needs the certainty of established regulation to develop and prosper. And the SEC has taken this later approach by relying on statutes that from its perspective have proven effective for decades. So that concludes my talk. Thank you for your attention, and I hope this was informative and interesting to you, and I'm happy to answer any question you may have.
Okay, so thank you very much for Dr. Mona's your wonderful and very informative, insightful presentation. Particularly, you like help us to understand how does the history and also the attitude and in terms of financial regulation and the financial innovation, how do we find a balance between that? So I think in the last decade, from digital payment and the equity crowdfunding, P2P lending, and the robo-advisor. There are so many new issues that are coming. And I think indeed it gives us like the investor or the consumer an alternative channel to get like maybe the effective and the convenient way for investment or for their wealth management. But on the other hand side, it also creates a lot of risk. So how do we really tackle of those difficult questions? I think maybe in terms of ICO, how does it really structure and what the token subsequently represent, maybe one of like the key issue when we trying to analyze the ICO. So I think with that, I would like to turn to our two distinguished panelists. So Professor maybe Donald, would you like to maybe share your perspective or any comment for the keynote speech?
Sure. Thank you very much, Hung Yi. And thank you very much, Simona, for this really informative presentation. I guess just one remark on the data that Simona presented, which I think is extremely clear. It shows that the US enforcement system works pretty well. We're using a test from 1946, formulated by the Supreme Court. And you can see the SEC is concentrating enforcement action in New York, in one of the best circuits of the United States, and then continuing to concentrate there while it's teaching the court, letting the lawyers teach the court more and more about this technology. And you can see probably a network forming of expertise in the Southern District of New York in this area. And then the no action letters forming the outside boundaries of what's enforceable. And I think that shows how well this enforcement strategy is structured. One small point that I was a bit surprised at when I was looking at other data from Cornerstone, because Cornerstone publishes data together with the Stanford class action research program. And it looks like the normal tendency of private actions to piggyback on the SEC, basically to let the SEC do the work of investigating and then file a class action using data and information generated by the SEC, seems to be less prevalent in this area. And I was a bit surprised, especially because it's a new area, and you'd think that the private sector would really benefit from the SEC. But on the last report on 2019, it showed a decrease in private actions where the SEC is remaining active. So just one small remark there. On the test on autonomy that Bill Hinman brings in, that we don't have a centralized agency in the protocol of blockchain, I think that might be falling into some of the same trap that we see in the people that say code is law. I think we saw this, and I apologize with the law economist here, but we saw some of the lawyers also with extreme respect beginning in the 1990s for economists. I think we're seeing some of that also for computer scientists without realizing that it's not autonomous, somebody's writing that code. And so there could be a central agency which is managing the autonomous aspect, which is essentially just automation of a central agency's activity. And I wonder whether the SEC might want to look at that. Along the same lines, on the point that Simona brought up in closing with broker-dealer custody of these assets, I think that also might be path dependence, because the idea of broker-dealer custody was brought in around 1970 when the stock market couldn't handle direct registration anymore, and we started going to the street name and the custodian indirect holding system. And I think we really should in the SEC be ready to get out of that and go back to direct, transparent holdings, and take these middlemen, the broker dealers, out of the picture. If we can, perhaps use an identifier number to allow us to understand who, or at least what category of investor owns these things, and that might solve the problem with the qualified investing for the Reg D exemptions. And then the last point, and this might go to a question in Simona, is whether the SEC, I mean, you state very clearly these missions of the SEC, right? We're protecting investors and we're allowing capital formation. And one of the things that becomes very clear when you live in a little financial center like Hong Kong is, although Hong Kong does have capital formation because we have these giant mainland companies listing, but in a financial center, it's often not about capital formation. It's about creating some sort of product where people can put their money. So you're not looking for money, you're looking for return. And you would imagine that in particular during COVID, where we have this impact on economy, which is quite predictable. It's hitting hospitality, it's hitting transportation, it's hitting mobility aspects of the economy, that money would be coming out and looking for something, some place to park, gold, things like this. And I wonder whether the SEC is looking at that other aspect where the money is actually looking for some place to be, as opposed to entrepreneurs looking for money to build their new widgets or found their new enterprise. And that's about all I have to offer. Again, thank you, Simona. Really excellent presentation.
Thank you.
Thank you, Professor Donna, for the comment and the question. I think that is very interesting because maybe 1 month ago, we also had a webinar and to invite the Abu Dhabi regulator to the webinar. And one of their strategies is trying to position themselves as the regional hub for fintech. So I think fintech also poses like a grab opportunity for the regulator to grab it as an opportunity to attract the investment. So with that, Simona, how do you respond for that?
Yes, actually, thank you, David. I think I have only two considerations. One, I totally agree. I think is right that private litigation has now piggybacked much in this to the SEC in this space. However, we were very surprised that that on April 3rd, 11 class actions being filed. Being filed at the Southern District of New York on the same day, and also the coincidence was pretty interesting. On April 3rd is a 1-year anniversary from the publication of the framework for investment contract analysis. So the other consideration about COVID, yes, I think you're totally right. I think investors are trying to get an alternative investment, and given the uncertainty and the sell-off in the markets, widespread in many of the traditional assets, you can see that starting. You can see that Bitcoin, so really virtual currencies, and in particular Bitcoin, and also stablecoin, have experienced a significant increase since the beginning of this year. And so there's a really, generally, I think is related to the search for greater interest in digital payments, given that we are in a remote stage at this point, but also it goes further to really looking at stable coins, in particular fiat-backed, fully capitalized, collateralized stable coin that as a possible alternative, investment alternative.
Okay, thanks for that. So I think with that, we also have Professor Iwashida, and he also kindly prepare a few slides. So before that, maybe may I have Simona, your assistance, like you move the mouse a little bit downside of your monitor, and you click participant. And because we need to switch like the host to our controller. Okay. So and then you can click right click one name called ZIBS, right click, and you can change the host to it, and our colleague will play control the slide for Professor Iwashida.
Can I, all panelists who can share?
Right, panelist, and I think there is one username called ZIBS.
Ooh, okay.
Shall I share my slide or?
Yes, now we because I think Zoom a little bit like need. Okay.
It's okay.
Okay. Yes.
It's okay.
Okay. That's good. So thank you very much. And I think Professor Iwashita, now we can see your screen sharing.
Okay. So this is my first page of slides. So good morning, everyone. My name is Naoki Yoshita, and I teach FinTech at Kyoto University. I mainly lecture to the graduate students on the FinTech from the various viewpoints, such as economics, legal, and information technology. Dr. Mola Shimona's excellent keynote speech evoked several memories for me. Based on some statistical graphs, I would like to take a short look at the recent history of the ICO. First, let's take a look at the ICO's growth in this impressive animation created by the Elementus. This is a quite famous animation, and you can see this one maybe in the movie sites and such as YouTube or so. And each ICO is represented by the balloon of different sizes, depending on the amount of the money it raises. You can see the bar chart. It's quite a little bit hard to tell, but you can see the bottom of the chart. You can see the bar chart, and this bar chart indicates the value of the ICO fundraising for each month from 2014 to 2018. And ICO increased rapidly in 2017. And by 2018, ICO had successfully raised a tremendous amount of money worldwide. How much did they raise? Although there is no consensus among them, the estimation values vary between 14 billion to 21 billion as of August 2018. Let's look at the next page. And from the late 2018 to 2019, ICO has declined dramatically. This chart is from the blog post of Long Hash, titled "The ICO May Be Truly Dead," published in October 2019. For these 15 months or so, ICO projects have been mostly unsuccessful. The reason why ICO has declined is that that fails to meet the expectation of investors. Let's look at the next slide, and this table shows a comparison of the advanced returns at tokendate.io. Here is a top 10 ICO token which is still circulation today, and according to this site, except for the very rare success stories like Tezos, the top of the top 10. In many ICO projects, token price dropped around 80 or 90%. The left-hand side, the red square shows that Tezos has 5.5 times of its the first issued price to the current price. But other ICO tokens are 0.02, 0.12 or something like that. So it's the most investors lost much money. So I think that SEC's action, which Mola's make a presentation before, toward ICO is too forgiving. And let's look at the next page. And this is the last chart. China's financial authorities issued public notice that's banning ICO in September 2017. Japan had similarly tightly regulated ICO in 1917. And from the investor's viewpoint of the investor protection, I believe that the effort of China and Japan are appropriate. And that's my comment. Thank you for your attention.
Okay, Professor Iwashita, thanks for that. And Simona, would you like to add for that?
Yes, no, you make really good points. I mean, there's a very heterogeneity among ICOs in terms of size, in terms of characteristics, geography, also type of investors that they try to attract, and also the point that has been there's this trend, increasing trend starting from 2017 and then decreasing starting from 18, and now it's almost very few are left. So some may argue that it's what is the causation here? It's economics, as you suggested. They don't really keep the promises in terms of profits returns. Or there's also contributing factors, and that's the debate out there from a regulatory policy perspective, where regulators have not created a supporting environment to facilitate capital formation. Again, I think finding, going back to my final point here, finding that balance between fostering innovation and slash capital formation and investor protection is very difficult. And as I mentioned, to the extent that a big proportion of these ICOs come with fraudulent allegations. So clearly, the SEC must police this environment, also to create the opportunity to create opportunity for the ICOs that are legit and they are really lawful and in compliance to grow. I wanted also to mention, maybe food for thought, I read an article that talked about the policy trilemma, and I found it very interesting. You may know already, but it mentioned that generally it's very hard when a policy seeks three different objectives. One, provide clear rules. Second, maintain market integrity. Third, encourage financial innovation. So it's very hard for regulators to achieve all three. At best, they can achieve only two. of this objective. And the author of this article talk about really policy trilemma, and they mentioned, for example, the Dodd-Frank Act that had the primary objective to, of course, restore market integrity, but at the same time preserving financial innovation, at the same time establish clear-cut rules. But in some cases, one may argue that the Dodd-Frank Act failed on this latter objective to create clear rules. And so it's possible that something to consider that the difficulty of finding that balance is also because there are different objectives, conflicting objectives that from a regulatory standpoint, regulators are trying to achieve.
Okay.
Could I make,
right. Yes, please.
Just one point, perhaps a bit more upbeat on the bubble bursting. It's quite common. I remember reading in 2003 in Germany when I lived there that who on earth would ever want to look at a video on a mobile device? That is crazy. The dot-com bubble was crazy. Why did we do that? And the infrastructure was being prepared for something that then became very mature later. And we're in the middle of a macro trend where markets are becoming fully electronic. And the idea of automating a share of stock or a bond and putting many features into it and putting it in the form of a coin, I think is something that we'll see permanent in the future. And these bubbles come and go, and they help us start to change the infrastructure.
Okay, and I think here I have two questions because like I also teach the fintech regulation in our business school. So I also frequently ask the question by the student because I think they are quite interested to see like how the government or the financial authority embrace the new technology or the digital innovation. For example, if we look at SEC or like the JOBS Act in the US in the very beginning 2012, when SEC announced the JOBS Act and followed by like its detailed guideline, I think maybe more than 50 or 60 jurisdictions, they adopt the model for that. And I think that is based on the security law and a new exemption for the crowdfunding. And in the UK, we also have the model that FCA that kickstart the regulatory sandbox. It is also like the government, the financial authority to work with those startups together to figure out the way how to regulate collaboratively. And I think in Japan, the cryptocurrency industry, that is very interesting because you have the self-regulation authority to help the financial authority to regulate the industry together. So I would very much like to get your all of your perspective on that. How do government should respond to those digital innovation, and what kind of the way that you think might be the new pathway to regulate the new industry, considering the social context in each jurisdiction? So that is the first question.
Yeah, so let me take a first pass on the, you mentioned JOBS Act 2012, and the mandate of JOBS Act, although it was welcome, really, it was positively welcome because I think there was a need for certain exemption like crowdfunding and also some like Reg A and including and extending general solicitation to regulation D. So the mandate itself in the JOBS Act was very stringent. I work on the economic analysis. I contributed to a drafting of the economic analysis of the regulation on crowdfunding, both in proposal and in adoption. And yeah, the mandate allow us really very small wiggle rooms. I mean, the cap of $1 million, the investment limit. So the Commission clearly And similarly also for Reg A, I think the Commission adopted a rule that followed the mandate, but also adopted the stand that a wait and see stand, in a sense that they would observe the marketplace, and if the conditions allowed for an extension of the offering limits and removal of some constraints, for example, in the investment limit, they would act. And so the proposal that just came in March of 2020 didn't surprise me, because it was really in the making at the time of the adoption. So I think in general terms, I think this in a new environment, in a new space like crypto space, the SEC has adopted really a similar position to wait and see and to learn, and instead of acting with new regulations that may be obsolete at the time when the rule is adopted after a long period of proposal and comment letters. So, and I think too, the way really that signals the attitude, the learning attitude, is the creation of the FinHub, that is a sort of it's a committee that allows basically communication dialogue with companies, so companies can have a conversation with the SEC and with SEC staff and talk about issues and regulatory issues before really taking action or initiating ICOs or anything else.
Okay, thank you, Simona. So Professor Iwashita, we know that you work for Bank of Japan for more than 3 decades, and I think in your career in the last 10 years, you mainly focusing on fintech. So would you like to elaborate on how like Japanese financial authority, their philosophy to respond for those digital innovation?
Okay. So, and Mola pointed out a very important point, that's financial integrity and also the financial innovation. Both is important, and so we need a balance, not only to regulate for the consumer protection or investor protection, but also we should promote the private sector's innovation to improve and introduce a new world of the finance. I think that a cryptocurrency or crypto asset brought in a completely new concept to the traditional financial market, and I don't think that a Bitcoin or other crypto assets would be used as the payment tool in even in the future. You can buy, I don't predict that you can buy something on your department store by using the Bitcoin, but I also point out that we have witnessed so many financial innovations and just after the invention of the Bitcoin. So Bitcoin ignited the new explosion of the innovation. So I think that the Bitcoin or Ethereum or ICO and STO, ICO, such kind of the new proposal, a new challenge, would be the seed of the new innovation, and we need to stand and wait and see what is going on, even in there is some risk of for the consumer protection or maybe the stabilization of the financial market. But if the trend exceeds, for example, in the end of the 2017, the Bitcoin price soared to the $20,000 US. At the time, G7 countries central bank governors and also the Minister of Finance warned that it's a speculative bubble. So you need to pay attention to the not to invest too much on this field. Basically, the central bankers or the financial ministry has no relationship between the such kind of the brand new crypto asset at all. But at the time, central banks and also the financial authority were afraid of the crash in the crypto asset would ignite the large tremendous crash in including the traditional financial market. So at that time, so if the financial authority considers that it exceeds some limit, then they will intervene into the market. So we can see that such kind of the action was taken by the Chinese financial authorities in the September 1917, and also in Japan in the almost the same time. Maybe the SEC in the US also studied about the DAO, and they pointed out that ICO is should be regulated by the Securities and Exchange law. It was also the another challenge, and also we have another example of the challenge from the New York State Department of Justice. Proposes the discussion between the Bitfinex or the Tether company. And in the beginning of the maybe April 1990, April 2019. At the time, the New York State Department of Justice pointed out and the problems of this stable coin, but the Tether lawyer didn't agree with the warning, and they expand the issuance of the Tether, and it was ignited another rise of the Bitcoin price. So always, not always the financial regulatory authority has the power to intervene in the market, because they are not accustomed to such new market. In the traditional financial markets, they have the close relationship between the financial institutions and they very long history of the regulation. But these new markets, we need to more study about what is going on in the market and what is the impact of the market movement. And also we have another problem of the cross-border regulatory issues. Maybe that the New York State Department of Justice cannot control the Hong Kong-based stablecoin issues. So what should we do is still in the discussion, and we every day we need to discuss what is going on and what should we do, as the viewpoint of the balance of the innovation and the integrity. Thank you.
Okay, thank you, Professor Iwashita. And David, we know that you work prior to your career in the university in 2008. You work as a security lawyer across many jurisdictions. Washington, Milan, Rome, and Frankfurt. And we know you're also doing a lot of research in terms of financial regulation, and also how does the financial authority should respond for those digital innovation. So we would very much like to get your perspective on that.
Thank you, Hong Yi. And also I'd like to, first of all, just thank you for giving me the opportunity to be part of this really interesting selection of jurisdictions, aside from the distinguished, learning from the distinguished colleagues, because we've got the United States beginning in 2013, post-Lehman, with a democratic SEC, but even under those aspects, the United States will not be looking at foreign countries to learn. They'll still be very confident that they can do it their own way and they can do it better. And then we have Japan, which is not a financial economy, it's a real economy. It's a high-tech economy, so it's going to be interested in tech. And it's not necessarily following the United States, it's kind of an alternative route. And then you've got Hong Kong, which is, like every small international financial center, tries to be a kind of a five-star resort for money, right? So we don't have any particular philosophy to follow, provided that we do what the international financial community sees as most attractive, right? So very different mixes here. And with our approach to this, one of the big problems in Hong Kong has been we share a border with mainland China. Mainland China decided it wanted to shut down a lot of this activity because it was too active. What I mentioned earlier with capital seeking return, we've been in a zero interest rate world since the financial crisis, and money is looking for return in real estate and then in crypto. And if Hong Kong had been as open as Singapore, for example, then we would have instantly turned into the recipient of the funds that were shut down in mainland China, right? Which would have sort of stymied, I think, a lot of the regulatory policy in mainland China. And so what you see in Hong Kong with the sandbox approach has been to allow innovation, but to contain it, to use the American approach of the securities analysis. That is, if it's a security, we'll regulate the offering. And so it's been relatively conservative while probably being just enough in favor of innovation, not to lose respectability as an international financial center, right? So, and I think the regulators have done a good job of threading this needle. As I mentioned before, I think we, as we saw, if you look at the Google Trends search for Bitcoin, for example, or for blockchain, they go through the roof up around 2017, and they come way down. And Naoki showed us the data on ICOs. They come up very quickly and they go down, but the residue of the basic technological structure, the basic innovation structure remains. And I think all of our jurisdictions want to make sure that we can allow the necessary experimentation and without suffering too much from the boom that comes from ignorance, essentially. The belief that somehow blockchain is magic, or that an ICO is not a security, although essentially you're putting money into it because you want to return like a security. And I think we've all managed to do a pretty good job. I think that the data that we saw, we're through the worst of it, and then we'll see the residue remain, because the markets are changing. They're completely electronic now, and they're mainly automated in the sense that in New York you have about 80% of the trading taking place through algorithmic trading that's computer driven and based on historical data that has its own problems. And then when you bring that sort of automation into a distributed ledger structure, then you have different questions, right? So it's a very exciting time. And I think as I said, the assortment that you've created, because China has been a kind of a giant sandbox, right, in the past for this very, very heavy innovation. Driving this, the United States brings in its tradition in the 20th century of expertise in securities regulation. Japan being a real economy with a very high-tech angle and extremely good regulation. And then Hong Kong, as I said, basically is going to be following this, because IFCs never want to lead. They want to do what the international community sees as most attractive. I mean, that's their business model. And I really appreciate you bringing this all together so we could see the various angles. And I think that from what we've seen from Simona's presentation, the future is going to be quite stable in this area, and consumers and investors are going to see a lot of benefits. And they haven't experienced a lot of dangerous Wild West activity. It's been contained pretty well through the enforcement.
Okay, thank you very much, David. So I think due to the time constraint, actually I have another question to have the discussion, but I think I will leave it maybe for the next opportunity when we meet either virtually or physically in Kyoto, in Washington, or in Hong Kong, or in Hangzhou. I think that will be great for us to stay in touch and to have further conversation on that. So thank you very much for Simona and David and now Yuki. We are very pleased to get your insight and perspective, particularly I think during the time of crisis, a lot of things is happening. So digital innovation keep revolutionize the world. But I think during 2020, we also see a lot of things. Now the world is changing and transforming and being redesigned. So I think that is very important for us to kickstart the conversation and have to step it for the first step. So with that, maybe may I also take this opportunity to announce like our next webinar, which is next Wednesday, 24th June at 6 p.m. Beijing and Hong Kong time, and 7 p.m. Tokyo time, and 6 a.m. Washington time. We have pleasure to invite Ms. Ann Kans, the Executive Vice Chair from MasterCard, and she will share the topic for FinTech and the role of leadership in times of disruption. So I also thank you very much for those following us online today. So far we have around 10,000 audience. So many thanks for our distinguished for sharing your insight. So we very much look forward to see you again.
Thank you.
Thank you very much.
Bye.
Thank you very much. Have a nice day.
Have a nice day.
Bye.
Bye.